For this, we will revert back to our Companies Act, sections 366 up to 375, and part 10 of the Companies Act talks about companies incorporated outside Kenya. And these are the provisions, as we have said, from 366 to 375. And it will apply to all foreign companies. They incorporated outside Kenya and wish to establish a place of business within Kenya. And the exemption is the said sections will not apply to a company registered under the Building Societies Act. We also exempt agents. When we talk of foreign companies, those who are doing their business through an agent will not fall under this category, because these provisions will relate to what is needed carrying on business as having a registered office here, despite them not being incorporated here. When we were talking about formation of a company, and we talked about the registered office and having the name affixed on that registered business premise, where are we likely to find you if you're operating in Kenya? So for the foreign companies, they were not incorporated. They were not brought into existence under our jurisdiction within the cover of Kenya. And while the provisions of the Act, as we will see, will relate to how they will operate, they will not have a certificate of incorporation bearing that when they were brought into existence. You see, for a company incorporated in Kenya, that date is very specific. It will be listed that on this day, and this company now, this individual, this separate entity from its members is now in existence and can now transact, can now own property, can now sue, can now be sued, can have assets, it can have employees. If it's a public company, it can trade in the Nairobi Stock Exchange. The Registrar of Companies will have all these documents. For this instance where it is already in existence, this separate legal entity is already in existence. It only needs a place of business in Kenya. And we have exempted agents. And we will start, as we started, with the name. We'll start with the name of the foreign company. And every foreign company where they want Kenyans or the locals, so to speak, to purchase its shares, they will also have a prospectus. And these prospectus will indicate where the company is incorporated. When we talked about the prospectus, that document that gives you a chance to know a company, so to speak, because the company cannot speak for itself, the prospectus is what will guide you. Do I want to trade in, say, Stanbic Bank? Are their shares in the Nairobi Stock Exchange? It is not incorporated in Kenya. Kenya is not their mother country, so to speak. It trades in Kenya, and where it wants to issue shares, where it wants to access debt, then it will have a prospectus. In this prospectus, it will indicate where is this company incorporated, and the place of business in Kenya where it is being carried out. It must be conspicuously exhibited. It's not being hidden. It's not in an alley somewhere. It's somewhere you can access, somewhere you can pinpoint. There is that company that operates. And the name of the company and the country in which the company is incorporated, it must be stated in legible letters in all billheads and all the papers that we are transacting with. They must show, and in all notices, that this company was incorporated in, say, South Africa, is currently carrying on a business in Kenya, and the registered office is in Westlands, whichever plaza, and on the 3rd floor. And if the liabilities of the members, if it's a limited liability company, these must also be stated in English, in legible, again, letters in every prospectus, and all other official publications of the company in Kenya, and to be affixed on every place where it carries on its business. Section, this is what we are saying, Section 3, this is the Insolvency Act. Let's see. The sections, as we have said, 71 on the name, and Section 366 provides on which documents will be provided to the registrar. This is our registrar in Kenya, the registrar of companies. And it must be done within 30 days of the establishment of the place of business. They deliver a certified copy of the charter, the memorandum and articles of the association, any other instrument that shows the nature of business. The memorandum defines why the company is in existence. The articles define the relationship between the company and its members. So, and they must be certified to be a true copy. The fact that it's not incorporated in Kenya means the registrar never had a chance to go through the original documents submitted. In the formation of a company in Kenya, the memorandum and articles are submitted, and where the registrar feels they are not at his discretion, he may refuse to register the company. So for these ones, they're certifying that what they're giving us here in Kenya is what is in that company, in that countries where this company was incorporated. That is where these are the same documents that are in that the mother country, so to speak. A list of the directors and secretary of the company, and it will contain their present Christian name, the surname, the postal address, their nationality, their business occupation, and if it's a corporation, the corporate name, the registered office, and the postal address, which is all the partners in a firm are joint secretaries. So all these information will be provided to the registrar. And it also provides a statement of subsisting charges created by the company as per the regulations of the Companies Act, not being charges comprising solely property situated outside Kenya. And we talk about persons resident in Kenya authorized to accept on behalf of the company the service of process and any other notice to be served on the company. and again, the full address of registered office of the company. These documents will be presented to the registrar. He will have a chance to identify if there are any anomalies. And the reason they want someone resident in Kenya is their chain link. If we need any information, can we have someone who we can actually bind to relate and relay this information from ourselves to yourselves? So section 67 provides on the certificate of registration and the power to hold land. Once the registrar is satisfied with all the documents we have listed, the charter, the memorandum, the articles, the charges, the list of the directors and the secretaries, a resident person in Kenya. Once they're satisfied and that they have complied with the provisions of the Companies Act, any certificate that the registrar will give will enable that foreign company. Now it can hold land. It now has the documentation. It has the identification in Kenya. Yes, it has the identification in Kenya. That it is recognized, that it has been able to satisfy the registrar that it can operate in Kenya, that within the Companies Act, it has done everything, all the requirements have been met, and therefore it is recognized and can be able to trade in Kenya. You see, before any trading is done, the registrar must satisfy himself that this is not a front. It is actually a legitimate business. It is not going to operate illegally in Kenya because it operates illegally elsewhere. So once the registrar is tasked with all this, and once they're able to ascertain that the documents presented provide the true and nature and the view of why the company wants to trade in Kenya, they're given that certificate of registration. And once they get the certificate of registration, it will have the power to hold land in Kenya as if it were a company incorporated under the Companies Act. You realize we have not said a certificate of incorporation because the company is already incorporated, but not in Kenya. So they're given a certificate of registration to show that they have complied with the Companies Act. The registrar is satisfied. The registrar has enabled them to commence business in Kenya. It has given them that identity. They can own land, they can purchase property, they are able also now to get the relevant documentations. This is the PIN, so that they're able to also pay taxes, where they have employees, any other document that they may need will now be availed because they have a certificate of registration. They have been recognized in Kenya as transacting business despite being incorporated elsewhere. They're legally now able to start to operate and continue transacting. We have that registration of charges created under Section 369. After the commencement of the Companies Act, and a foreign company which has established a business in Kenya, if they execute a charge outside Kenya, comprising property both within and outside Kenya. Now that they're able to hold land and they have secured debenture, so to speak, they have secured debt, and a charge is to be, it will to secure this debt. If it's in both that foreign company and in Kenya, then it shall not be necessary to produce to the registrar the instrument creating the charge if the prescribed particulars and a copy of it are delivered to the registrar for registration. The company has secured funding, and due to its ability to hold land in Kenya, that land in our country is what is, maybe part of that is securing this debt. Probably they have bought a building in town, and this building in town, part of it is able to secure funding, and part of another building in South Africa, the mother country, is securing more funding, probably to enable it to expand in Kenya. That instrument, if created in South Africa, the registrar need not see the physical document. You remember we said a register of creditors is kept with the registrar and the amounts held with them. So in this case, what they will need is to have a copy that is verified, and it will be kept for registration. That original instrument, if it was an agreement, it's a charge saying that LR number this, found in Nairobi, Kenya, worth this amount of money, has secured a debt of 50 billion, and in South Africa, situated in Johannesburg, worth a million rands. That instrument has been executed in South Africa. The registrar will not need to see the physical thing. It will just need a certified copy of what is being done, and it will be kept in the register with other documents provided. But within 60 days, they're not given forever, or they are not given an extended time. Whenever that instrument is executed in South Africa or whichever country, they'll be given 60 days to deliver to the registrar in Kenya. Or in the case of the title deed, a deposit of the title deeds, any document that was used. So within 60 days of you securing the funding, within 60 days of you charging this property, deliver to the registrar in Kenya for registration purposes. And we have the accounts of foreign companies under Section 370. So every calendar year, a balance sheet, profit and loss account must be presented to the registrar. And if the company is a holding company, group accounts, as we said, the consolidated balance sheet, consolidated profit and loss. And they must contain the particulars under the Act. And provided that a foreign company shall not be obliged to comply with the provisions relating to foreign companies if it's incorporated in the Commonwealth, and it would have been exempted had it been incorporated in Kenya. We talked about the companies which are exempted from presenting these group accounts. Private companies where they may not have their provisions, they're not trading in the public. So if those exemptions, if that company was to be incorporated in Kenya and the exemptions would apply to it, then the Act will provide the similar exemptions and cover it under this same Act. And for these accounts we are saying, they must be in English. Despite the country where it was incorporated, they may have another national language. They may probably say Russian or Chinese. But for the documents presented to the registrar in Kenya, these documents must be in English. And they must be signed by a director and a secretary for verifying the truthfulness of these documents. So where they're not written in English, there must be a certified translation such that any individual can be able to access, can be able to read, can be able to make sense of what is written down. And Section 372 is the service on a foreign company. Any process or notice required to be served on a foreign company shall be sufficiently served if addressed to any person whose name has been delivered to the registrar and left at or sent by the registered post to the address which had been so delivered. And where there's death or someone has ceased to reside, then they can be served by sending it to the place of business that the company provided to the registrar, that this is where we are operating, this is where we are able to, you can reach us. Part of the documents to be presented to the registrar, we talked about the names, postal addresses of someone or more persons resident in Kenya, authorized to accept on behalf of the company a service of process or any notices. This is where we are saying it's important. There must be someone who can be served if there are any issues. If the registrar seeks to find out, there must be someone they can communicate with. And the returns are according to Section 368, where if the articles are altered, if the memorandum or if that charter of that foreign company is all altered, then the registrar must be given a certified copy. They're not exempted, just as we said in a normal company incorporated in Kenya, where a meeting is set, resolutions are passed to alter the articles, to alter the memorandum. The registrar is notified of these changes in writing. And where any changes relating to this foreign company have been made within 60 days again, these changes are certified changes, certified resolutions that relate to any alteration, whether in the memorandum or articles, will be provided to the registrar and they will update the register. And where there's a winding up order commenced in that country where the company was incorporated, within 30 days of that winding up order or commencing these winding up proceedings, the registrar must be given the relevant particulars. A return must be given to the registrar on these particulars, and the advertisements must be done in the local dailies, advising the public that this company incorporated outside Kenya but trading in Kenya and listed on the Nairobi Stock Exchange, if so listed, is seeking to close up shop, close up business. the head office in that foreign country is seeking to wind up. So within 30 days of the notice, or 30 days once the works have been started on winding up, the registrar must be notified.